after this judgment has been passed, if there are societies, as in apartment residential societies who are registered under the Cooperative Societies Act, then what happens to them?
Since RERA provides you that choice, you can opt whether you want a 1972 or a cooperative society. So if you're a mixed use, then you can't form an association under KAOA 1972.
Good morning.
Hi, good morning.
Thank you for coming back again.
My pleasure.
Our earlier conversations have had a lot of interest and a lot of people have engaged in conversations. They've sent out a lot of emails. We were talking about the RWA, that is Residents Welfare Association, Management Committee members taking over the society from the builders.
Yes.
Recently, in May of 2025, there was a new ruling that was passed by the courts in Karnataka. I think it was for Ramky 1 North. They had made a lot of clarifications and there's a lot of doubts that were cleared. Why don't you take us through some of those and we can have a conversation on that.
Right. So, the Honorable Karnataka High Court in the month of May 2025 passed a judgment, like you said. It's called, the apartment is called Ramky 1 North Association. So what happened in that case is some of the residents or owners of the flats there filed a writ petition before the Karnataka High Court.
Filed a
writ petition
okay.
before the Karnataka High Court against the association which was formed under the Karnataka Cooperative Societies Act.
Okay.
And they said that, look, in my sale deed, it says that the builder should form an association under the Karnataka Apartment Ownership Act. However, here there is an association or a society that is formed under the Cooperative Societies Act.
Okay.
And therefore, this cannot be a legal association as regards the sale deed is concerned.
So are you saying that there are situations where the sale deed itself mentions the type of association that needs to be formed?
Yes, generally in most sale deeds, they will mention that an association will be formed. Some of the builders specify under which act. Most builders don't specify, they just say association and leave it at that.
Okay. In your case, in this case, in Ramky 1 North case,
they had mentioned
that it's going to be the Karnataka Apartment Ownership Act. What happens if after this judgment now, if there is an agreement in the sale deed that says it's going to be the Societies Act, so it's going to be overruled?
Right. So let me clarify what the judgment said. So the judgment said that, look, because the sale deed says this, and in the past, the Karnataka High Court, in a couple of other judgments, have also upheld that if you are a residential apartment, then the law that applies would ideally be the Karnataka Apartment Ownership Act, which is your KAOA 1972 Act.
Okay.
Now, RERA, of course, under Section 11 also says that associations can be formed or societies can be formed. It clarifies that, it doesn't clarify, but it gives options to builders to register either an association or cooperative society based on the choice of the builder. Now, if your sale deed doesn't specify which association under which act ought to be formed, since RERA provides you that choice, you can opt whether you want a 1972 or a cooperative society. But the High Court has time and again come forward and clarified that, look, if you are a residential association, then you ought to form under the Karnataka KAOA 1972 Act.
Correct. Sorry, I want to just clarify. You kept mentioning residential society.
Right.
That means that what percentage of the total space is residential, or even having one shop where, because now a lot of societies have a shop, a gym, a spa, etc. What converts a residential to a commercial or a mixed use category?
So that arises out of your sanction plan.
Okay.
If your sanction plan is a residential sanction plan, then it's a residential apartment.
Okay.
Because in residential apartments as well, under the bylaws, 10% can be for commercial. So these things that you're talking about are not pure commercial.
Okay.
They are more in terms of common area where these shops and other things are in place for the use and benefits of the residents.
Okay.
So the primary purpose will be residential.
So there are two things I have. One is you said 10%. 10% of what?
10% of the entire land.
So if the property is 10 acres,
Or your built up area.
okay, so whatever has been constructed. What happens to a situation where, for example, we have a society which has got 2 towers, it's got maybe 10 floors each, and there are 100 units. The bottom 2 floors are taken for commercial use. There may be a gym, there may be a coffee shop, there may be a spa, and there's something else. As long as it is for captive use of the society, then it will remain as a residential thing. If it gets opened to public, then does that change, even though the sanction plan says that it is a residential use?
So, what you mentioned, the examples such as gym, spa, these come under amenities,
Okay.
which every apartment provides.
Okay.
So, in fact, these amenities in the sanction plan itself is designated.
Okay.
So, it can't be a situation where there is a flat that is built for residential use, but the builder tomorrow says, no, I'm going to convert this to something else.
Okay.
Because then you will have problems obtaining OC.
Okay.
So generally, any apartment which is built, all the common areas and the amenities that they're going to provide is already demarcated in the plan itself.
Okay.
So it's an approved plan. So as per the approved plan, these don't classify to be commercial per se.
Okay.
But there are a lot of apartments which have mixed use, where the first 4 floors in the plan itself is for shops. And thereafter there are residential apartments. Those come under mixed use.
Correct.
So if you're a mixed use, then you can't form an association under KAOA 1972.
Okay.
Because that is purely only for residential purpose.
Okay.
Then you will have to form an association under the Cooperative Society or Companies Act.
Got it.
As you prefer.
So it all depends on the sanction plan.
What type of apartment you are, yes.
Okay. Sorry, we kind of digressed off
Yes.
of the
So
ruling.
what the Karnataka High Court did is that it clarified based on the other judgments the Karnataka High Court was already decided. So there was another important judgment that came out called Shantharam Prabhu versus Dayanand Rai Opai. I'm not very clear. But this was also passed by a single judge of the Karnataka High Court about a year ago, wherein a very detailed order was passed to state that, look, there is also something called the Karnataka Ownership of Flats Act 1972. Now, generally, when an apartment is under construction or before the builder sells the apartment at the time of sale, what applies to people who have an intent of purchasing the apartment, who have entered into agreement to sell, will be a Karnataka Ownership of Flats Act. Now, what the judgment said is that, look, once the builder has sold the apartments and an association has to come in place, ideally the intent was to move to Karnataka Ownership Act 1972. So that clarified, saying that the minute you opt, because Karnataka Apartment Ownership Act is an act where you have to opt, saying I want to be ruled or governed by this statute.
Okay.
The minute you make that election, then automatically the Karnataka Ownership of Flats Act will not apply anymore. The statute that will govern you and apply will be the Karnataka Apartment Ownership Act. However, if anybody chooses not to elect Karnataka Apartment Ownership Act, but if they choose to, for example, form a society under the Cooperative Societies Act, then the act or the statute that will govern your society would be the Karnataka Ownership of Flats Act.
Okay.
That was a clarification that came about. So far, no judgment says there is a bar in terms of forming a cooperative society. However, the reasoning has always been that, look, if you are a residential complex, then the act that ideally you should be following or electing to follow should be the Karnataka Apartment Ownership Act.
Okay.
So what I would like to clarify is that there are PILs that are filed regarding the Karnataka Apartment Ownership Act. But thus far, as far as May 2025, the court is still of the opinion that the Karnataka Apartment Ownership Act 1972 is the act that should be made applicable for residential apartments.
Very clear. There was one point. You said that when an apartment unit is sold, what is that threshold that says it is yet to be sold and sold. What is that?
It's your sale deed.
It's the sale deed.
It's your
So
sale
as soon as a sign the sale deed, then it is considered sold. Okay. So now, after this judgment has been passed, if there are societies, as in apartment residential societies who are registered under the Cooperative Societies Act, then what happens to them?
They're still a proper elected body.
Okay.
There is no issue. You can still operate your society under the Cooperative Societies Act. The only distinction is in the event your sale deed, like what happened in Ramky 1 North. Your sale deed specifies that your association has to be through signing a deed of declaration, or it says formation under KAOA, then the sale deed mandates, so a contract mandates that, and the builder is obligated to form an association under KAOA. However, if there is no such mandate in your sale deed and you've opted to form an association or a society under the Cooperative Societies Act, you can still exist.
So
what you can't do is you can't form an association or a society under the Karnataka Society Registration Act 1960.
Okay. So there's nothing wrong in forming any of these two,
Yes.
apart from the Societies Act 1960.
60.
1960.
Yes.